Hearing in the appeal, Public Prosecution Office of the Athens Court of Appeal against O'Connor.
Yes, Mr. McLean.
If I can just outline what I propose to deal with in my submissions this morning. I'm going to briefly outline the facts which are largely uncontentious in this case. I then want to turn to examine some of the key provisions of the 2003 Act. Then I'll turn to look at the relevant Northern Ireland procedural rules. I will then examine three important judgments: the decision of the House of Lords in Michelli, the Supreme Court decision in Pomachowski, and the decision of the Divisional Court in Chegfu, before turning to the Northern Ireland Divisional Court's decision. That's an outline of the submissions this morning.
Can I raise one matter that wasn't discussed in the parties' cases, but which it'd be useful for us to have your assistance on at some point during your submissions? The statutory requirement under Section 26(4) concerns the giving of notice of application for leave to appeal.
Yes.
Now, in this case, Mrs. Justice Bride extended the period for the making of that application and granted leave to appeal, and we have her orders, and those orders have not been challenged, as far as I can see.
Yes, my Lord. Well, I will come to it again when I go into the submissions, but it is a point that's worthy of consideration, because the Divisional Court came back to the issue and considered and raised the question of whether or not there was a proper appeal before it, and that's why we embarked upon this examination of 26(4) in its application.
Yes. Well, I'll be grateful for your help when we come to that.
I'll come back to that.
It's not immediately clear on what basis the Divisional Court dealt with the issue at all.
Yes. My Lords, the relatively uncontentious facts in this case arise from the extradition proceedings involving Mr. O'Connor, who was subject to an accusation warrant dated 11th of March 2013, seeking his return to Greece to face a series of serious criminal charges in respect of offences related to drug trafficking. He resisted his proposed extradition on a number of grounds, including potential breach of Article 3 of the Convention. And the Court will have seen that the Recorder of Belfast, who deals with these cases at first instance, considered the case over a period of time, received assurances from the Greek authorities, and was satisfied that the extradition order should be made. And the extradition order was made on the 7th of December 2015, at which point the procedural time limits were engaged. The requested person's solicitor filed an application for leave to appeal on the 16th of December 2015, just within the time limits. But the procedural feeling was that notice was not given in any formal form to the requesting state through the Crown Solicitor's Office or any of the other agencies involved. And that's not in dispute. It's candidly accepted in the Solicitor's Affidavit. For your note, you'll need to turn to it, but it's in MS 221 of the electronic book. The application for leave was then considered by the single judge, as the President has raised with me, and Madam Justice McBride dealt with this in her decision, which you'll see at MS 211 of the electronic book. And the issue of extension of time and compliance with the rules was raised with the judge at first instance on leave, and she dealt with the issue at MS 218, paragraphs 26 and 27. And you'll note in particular that she reached the conclusion that in the circumstances of the case, in the absence of prejudice to the respondent, she considered that leave should be granted as an arguable case that the court has power under the rules to extend time, and there are grounds on which it should exercise this power. So the judge at that stage reached the conclusion that she could extend time, and we say now, and did say then, that there was no capacity to extend time, looking at the actual application of the statutory scheme and Section 35.
That's, at the end of the day, that's beside the point if she did it and there's no, and a decision hasn't been appealed. we see the order she made on page 219.
Yes.
It's ordered, 1, that time for service of the notice of appeal be extended, and 2, that the application for leave to appeal be granted.
Yes, I accept that. I'm not take issue with that. As I've indicated, the matter came before the fuller version of the Divisional Court with the Lord Chief Justice presiding, and the Court raised the question of whether or not there was an appeal properly before it, and whether or not, in fact, time could have been and should have been considered extended in this case, which is why the matter was the subject of further debate and consideration before the Divisional Court. And you'll see in the papers submissions from both parties addressing that question before the Divisional Court as to whether or not the matter was properly within time. In parallel to that, in these proceedings, there was a process going on in respect of Article 3 compliance in the Greek prison service. So the proceedings proceeded in a parallel track, submissions being made about the capacity for extension of time, and further information being sought in respect of the conditions in a particular prison, Korydallos, in Greece. But the Divisional Court considered as a discrete issue the question of the compliance with the time limits, and you have in the book at MS 294 the judgment of the Divisional Court of 15th of August 2017. And you'll see at paragraph 1 that Lord Chief Justice describes this as a purported appeal for the court, and addresses then the question of whether or not the application was properly made and within time. You'll see at paragraph 3 the court's consideration about 5 lines at the bottom of the question of whether or not the appellant had in fact a valid appeal before the court, and the court then moves to consider the detail of the relevant jurisprudence on the capacity to extend the time limits. The ultimate conclusion of the court, I'll come back to this in a little more detail if the court wishes to explore the issue, but the ultimate conclusion of the court here was to depart from the consideration of this issue by the Divisional Court in Shegfu, and the court determined that in this case the failure to give notice to the requesting state was not fatal to the appeal, and the appeal should be allowed. And we say, and the court, in certifying the question, recognised the issue, that this approach is potentially problematic insofar as it introduces a differential approach with respect to compliance with an international treaty obligation as between the different jurisdictions of the United Kingdom. So the approach in the High Court, the Divisional Court in Northern Ireland, is to follow O'Connor. The approach in the Divisional Court in England and Wales is to follow Shegfu. The position in Scotland we've been unable to determine definitively, despite making inquiries about that. So we have a differential approach within the jurisdictions of the United Kingdom. We also consequently have uncertainty in an area of the law which had been the subject of recent amendment in 2014, where the application of strict and clear time limits are an essential feature of the statutory scheme.
Can you help me? Madam Justice McBride, having granted the application for leave to appeal and having listed the appeal against extradition for hearing, on what basis did the Divisional Court have jurisdiction to consider again the question of leave to appeal? Well,
Lord, the court appears to have formed the view that the first decision, the leave decision, was an improper decision, and that the extension of time wasn't a valid extension of time.
Yeah, but if it hasn't been appealed, and I'm just puzzled by this. I appreciate I'm not familiar with procedure under the Northern Irish Rules of Court, but I'm puzzled as to how the divisional court would have jurisdiction to consider the issue if the issue had in fact been decided by Mrs. Justice McBride and no appeal had been taken against her decision.
Well, I think I'll reflect on that point, Lord, and perhaps come back on it. As we've all proceeded on the basis that the Court of Appeal, the Divisional Court had jurisdiction to determine the issue again, and certainly they proceeded on that basis, and that's why they've certified the question for this court's consideration. Yeah. And our understanding of it at the time was the Divisional Court was concerned that the single judge had exceeded her own jurisdiction in extending time, bearing in mind that there is a clear statutory bar in Section 35 subsection 6 of the Extradition Act, which says you cannot extend time. There isn't a facility for extending time. So the court clearly was of the view that they may not have a valid appeal before them, which is the way that they put the point, and the issue was therefore ventilated again.
A little bit odd, though, isn't it? Because there's not even a mention of the order by Mrs. Justice McBride.
In the Divisional Court's...
In the Divisional Court's decision.
It is. The court clearly took the view that this was a live issue properly before them and grappled with it. It's also worthy of note, I think, that this was, in time, one of the first, if not the first, extradition cases after the new rules came into effect. So they came into effect, they commenced, I think, on the 7th of December 2015. The order was made on the 7th of December 2015 by the recorder in Belfast. So our Divisional Court seems to have formed the view this was an issue of some novelty which required a further determination.
Yeah.
Was there a hearing before Madam Justice McBride?
That's a good question. I wasn't involved in the case at that time. It may have been dealt with. It was. No. I'm told by my learned friends that it was dealt with on the papers in chambers, as would often be the case.
And I was trying to identify the submissions that were made available to her prior to her decision. There is a little bit of confusion, I think. Page 206 is one of the submissions made on behalf of the requesting state, but it's got two dates on it. One is 2016 and the other is 2017. Yes. So I couldn't identify in the papers any written submissions by the requesting state to Madam Justice McBride. There's a letter saying they want to raise this point, but there are no submissions. And so if you could identify those at some stage, if there were any.
Lord, I don't believe there were any. The document you see at MS 206 bears my name. That's a document for the hearing on the 18th of January 2017 in the Divisional Court, and I wasn't engaged prior to that.
In relation to that hearing, on page 75, which is in the Respondent's written case, we're told that at the first review before the Divisional Court on the 18th of January, counsel for the requesting state requested that the issue of breach of a time limit for appeal should be raised before the single judge at the leave stage. In other words, Mrs. Justice McBride. The Lord Chief Justice granted leave for the parties to file submissions with the single judge on the issue of jurisdiction. So I presume there's some order of the 18th of January to that effect. But does it appear that notwithstanding what the Lord Chief Justice ordered, no such submissions were actually filed?
It's a point we can have checked. It predates certainly my involvement and my learned junior counsel at the time, Mr. McAllister's retired from the bar some time ago, but we can check the point. It does appear that the requesting state was raising the issue with the Divisional Court almost immediately.
Yes. And the Lord Chief Justice, not surprisingly, envisaged that the issue would be dealt with by the single judge at the stage of deciding whether to grant leave.
Yes.
The only representation from the requesting state that I can find is at page 210, which is just a bold letter.
Yes. Yeah, that's the next year. The title pages.
And Ms. McLean, if the proceedings before Madam Justice McBride were ex parte, by an ex parte notice of motion, that order would stand unless there was an application to set it aside. And that would be a formal application to set aside the ex parte order that Madam Justice McBride had made.
Yes.
As opposed to an appeal procedure. Was there a formal application to set aside the order?
No, there's no application to set aside. Again, I wasn't involved in it. It appears to me this was an application dealt with on the papers in chambers by the single judge.
Yeah. But even if it's dealt with on the papers by the single judge in chambers on an ex parte basis, presumably one has to then apply to set aside the ex parte order.
Yes, on a strict application of the rules. What happened in this case didn't follow that path. The Divisional Court decided to grapple with the issue afresh when it came before them. I recognise the procedural irregularities that appear to be the case here. I can't be definitive about it, but the position, I suppose, is that we are still left with a Divisional Court determination on these issues, which our courts continue to follow, rightly or wrongly, notwithstanding the false starts that may have occurred here.
If there has been a lack of compliance with the rules, that could be corrected under Order 2, Rule 3.
Yes.
Insofar as if you failed to take a step and to bring an application, that, in the discretion of the court, could be corrected.
It could be, my Lord. And that could regularise any difficulty with the proceedings to date.
Why is it appropriate to regularize it if, in the result, somebody who would be subjected to a substantial risk of inhuman and degrading treatment would be sent back to a country in which they would be so subjected? Why, in such circumstances, would one wish to regularize the proceedings?
Well, I think the answer to that is in part whenever the panel granted permission for this appeal. Lord Kerr was on the panel, I think, but we were asked to provide an undertaking, which the appellant did, that there would be no attempt by the requesting state in United Kingdom proceedings to revisit the substantive decision in this case. So the requested person is not in jeopardy of return to Greece by the United Kingdom authorities. And the court granted permission on that basis. You'll see a reference to an undertaking in some of the correspondence. So this court appears to form the view that it had the certified question before it raised an issue of importance, and that on a no detriment domestically to the requested person, the issue should be considered. So I suppose that, my Lord, is why there is a basis for correcting any irregularity. If that's required.
Yes, thank you.
So, my Lord, I recognise there's plenty of awkwardness procedurally in this, and with that in mind, we've taken the starting point really as the Divisional Court's determination of this question in the August 2017 decision. The August 2017 decision, the decision that gave rise to the certified question, is one where the court considered what had arisen in the Shegfu case, had regard to Pomachowski and Michelli, and decided to find a means of permitting an appeal to proceed, notwithstanding the failure to comply with the procedural requirement in the rules. One reflects on this and rhetorically considers on what basis did the Divisional Court take that step. It appears from a reading of the relevant jurisprudence that in effect the Divisional Court was constrained by Michelli, House of Lords decision, similarly constrained by Pomachowski's endorsement of Michelli in the Supreme Court in 2012, had SEGFU as a guide and could, in our submission, if it had adopted a Section 3 reading of the relevant provisions, perhaps created some latitude. But one of the features of the Divisional Court's judgment, and we'll come back to this, is that they do not actually express that this is a decision based on a Section 3 reading of the relevant provisions. And that's problematic, again, for a number of reasons, but we will see when you actually turn back into the earlier judicial considerations of this issue, there were reservations about whether a Section 3 reading was in fact possible or appropriate in a case like this, because it requires a Section 3 reading of a 2014 piece of primary legislation, where the reading in itself, in one view, involves going against the grain of the statutory provisions, the classic Guyton, Godin, Mendoza line of authority. So I pose the question rhetorically, how did the Divisional Court get to its endpoint? What was it doing? Was it engaged in a Section 3 process? And if not, well, how did it juridically get to this outcome? Can I, if I may, my Lords, turn briefly to the statutory scheme and look to the provisions of the Extradition Act? We did yesterday evening, and I apologise for this, send in some hand-up extracts, some additional extracts of the 2003 Act, which hadn't made their way into the authorities, and those extracts are really the provisions from Section 26 through to 35 of the Extradition Act. I think the Court needs to see all of those provisions in order to understand how the scheme works.
They've been added to our electronic bundles this morning. So I think we have everything we need.
Well, according to Pomachowski, there's a number of other provisions, Part 2 of the Act, that have similar wording.
Yes.
Which we probably ought to have for completeness, I would have thought.
Yes.
It's the same approach to other appeals under the Act. Well, I don't think we've got those sections.
I think what we'll do...
Around 100, 105, 110.
Provide the Court with the Part 1 and the Part 2 relevant provisions. I don't have the new MS numbers for the bundle, but we have Section 26 itself at MS 349. And this makes provision for appeals against the extradition order. The Section 26 provision was a subject of quite considerable amendment in 2014 by the Antisocial Behaviour, Crime and Policing Act. Introduced new elements to Section 4 and Section 5. In substance, what those amending provisions did was introduce a leave process, which hadn't previously been there, and introduced the entirely new subsection 5, which was the mechanism for giving some latitude in the event that there wasn't compliance with the time limits. So it's a point to note that when we look, and when the Court comes to look at Michelli and Pomachowski, those are pre-amendment cases, both of which involved the scenario where there was no application for leave to apply, where there was a appeal as of right by way of originating motion and a requirement for service. We now have this two-phase of process with an ex-parte application for leave to appeal and consideration thereafter. So it's a modification. The concepts are the same, we would say, between Michelli and Pomachowski and the contemporary approach, and one can properly read across the principles from those cases, but it's important to bear in mind that we're now dealing with a different statutory structure. Looking to Section 26, subsection 4, the court sees that the insert now is a notice of application for leave to appeal must be given in accordance with the rules of court before the end of the permitted period, which is 7 days, starting with the date on which the order is made. So, very strict 7-day time limit. Notice has to be given in accordance with the rules of the court. And as we'll see, all 3 legal jurisdictions in the United Kingdom promulgated rules to deal with these new provisions. The court will also have seen, and it's referenced in the Pomachowski judgment of Lord Mance, paragraph 34, a reference to a parliamentary review, a review conducted for the benefit of Parliament by Mr. Justice Scott Baker in 2011. And that review recommended changes to the extradition regime in the United Kingdom. 2 of them are important. One was the introduction of a leave stage, and the other was a change in respect of time limits. And the review proposed a more generous time limit, moving from 7 days to 14 days. It also considered, but did not recommend, the introduction of a latitude to, by way of discretion, extend time. So the Scott Baker review fits into the overall statutory process in 2011. And you can see that the court in Pomachowski was looking at what Scott Baker had considered and recommended. But what the Baker review recommended was enacted in part. So we see here subsection 4 introduces the leave requirement. Subsection 5 does not introduce the extended timetable from 7 to 14 days, but introduces a bespoke arrangement. And the language of this provision has been the subject of commentary in Shegfu and in our Northern Ireland Divisional Court. So where a person gives notice of an application for leave to appeal after the end of the permitted period, the High Court must not, for that reason, refuse to entertain the application if the person did everything reasonably possible to ensure the notice was given as soon as it could be given. So that's the facility to mitigate against the rigid application of the 7-day time limit. And the issue that arises in this case, arose in Shegfu, has arisen in other cases in the Northern Ireland jurisdiction, is what happens whenever the default in respect of the time limits is not the responsibility of the individual, but of their solicitor, as happened in this case. And we have, again, some learning from the authorities in respect of that. I indicated that there are parallel or broadly parallel arrangements in Section 28 of the Act.
I'm sorry, just before we leave Section 26, it may be worth just noting the way in which the word person is used in the section. In subsection 1, the starting point is if the appropriate judge orders a person's extradition, the person may appeal. And then we're told an appeal lies only with leave. And then 5, there's further references to a person.
You'll see in Shegfu, Lord Justice Burnett tries to unpack this because arguments either way about what person speaks to here.
The person must, on any view, be the individual, mustn't it? The question is whether somebody else's acts should be attributed to them in a particular context or not.
My Lord Legate, one sees the point immediately. The person must at least include the requested person. It must also, we would say, and Lord Justice Burnett agreed, I think, with this, in subsection 5, it must also include someone other than the requested person, because it's not the requested person who gives notice of the application for leave to appeal. It's in this case, the solicitor who gives the notice. So it must embrace something wider than the requested person themselves. And one of the features of subsection 5, again, is that the word person is used twice in the same sentence. So it must, we would suggest respectfully, have the same meaning or connotation within the text of the same sentence.
But isn't Lord Legate right that the the words "the person" must refer to the individual whose extradition has been ordered.
Yeah, yes, but the question is whether it's only that, my lord. In our submission, it's not only that, and it's can and must be broad enough to include the actions of another person, in this case, and other cases, the solicitor, who will be the person.
But that's because they're treated as being the person's actions, not because the person means something other, also includes the solicitor.
Yes.
I mean.
Yes, I mean, you're saying if a solicitor gives notice, for example, on behalf of the individual whose extradition has been ordered, then that is treated in law as the person giving notice of the application.
We say it follows when one comes to examine the second use of person in the passage, which is the operative provision for the purposes of these types of cases. Then that embraces both the conduct of the individual and the conduct of the solicitor. So the question is whether or not the solicitor, acting as the agent of the person or on their behalf, did everything possible to ensure the notice was given. And in this case, it's candidly accepted that they did not, because notice wasn't given until the 4th of January, long after the time limits had expired. And that reasoning is the reasoning which seems to find favour with the English Divisional Court in Shegfu. And they take quite a robust and direct approach in respect of this. The Northern Ireland Divisional Court looked at that aspect and took a different view. But we can, again, we recognise that that's the key provision. And when we come back, if we may, briefly in due course, to look at Pomachowski and the Scott Baker Review, you'll see what Lord Mance, in paragraph 39 of Pomachowski, and I'll come to this in a little more detail, considered that the question was whether or not the litigant personally had done all that they could in order to give the relevant notice. And that was a speech which was made before the 2014 reforms. The 2014 reforms had the Scott Baker Review looking at the prospect of a potential extension of time, and Parliament decided not to adopt the formulation that Lord Mance had sketched in paragraph 39 of Pomachowski. So we say, looking at those materials, it favours the construction that the court in Shegfu adopted, the one we contend for, that the default of the solicitor in a context like this does have the same outcome as if it was the default of the individual.
But you're not saying, are you, that it's an impossible proposition that you could give person a different meaning in relation to the two sides of subsection 5? Because it may be that one has to look at the context and to see what the effect of giving a particular meaning to the word person would be. You may, for example, take the view, well, it may be perfectly acceptable if one's talking about benefiting someone, but if one's prejudicing someone, one might take a different view. I mean, that would be open to us, would it not?
Well, I'm not sure that it is, my lord. It's a curious thing if the court is to interpret the same word to carry two entirely different connotations in the context of the same sentence.
I don't think it's the word. It's rather the attribution of conduct. I mean, what you're applying is the maxim qui facit per alium facit per se to gives notice. You can do it personally, or you can do it through an agent. And the question really is, do you adopt an identical approach to the concept of doing everything reasonably possible?
Well, we would submit there's a symmetry to the approach that we're contending for, and one reaches for or tries to find a guiding principle that would lead the court to break that symmetry. What is it that takes us to disrupt it in that way? And we say it's not obvious. Whenever one looks back to see that here we have a very deliberate choice by Parliament, recognising the difficulties that can arise in this context, as they did, recognising the difficulties that Lord Mance had highlighted in Pomachowski, being offered a particular solution and not taking it, and putting this formula in place,
Well, when you say that, I mean, the only part of the Scott Baker recommendation they rejected was replacing one time limit of 7 days with a slightly longer one of 14 days. But they took really the more significant point, which was the need for discretion to deal with deserving cases effectively.
They did, in a particular way, they didn't introduce a just and equitable extension or in the interest of justice extensions one might see in various statutory formulas. They've adopted a very bespoke and specific mechanism in this case. Yeah. And again, one reads the statute in its context, and the statutory scheme as a whole is replete with guillotine, hard-edged, time limit provisions.
Yes, it's also full, this legislation is full of guarantees of human rights. And I mean, the argument against you, obviously, is that given the background in Miceli and Pomachowski, Parliament's unlikely to have intended to enact legislation which could have such arbitrary results as and cause irremediable harm, as would result from the interpretation given to it by the Divisional Court in England and Wales.
Yes, I recognise that's the case it raised, my Lord.
Just on the wording, though, I mean, it's your case that requires, as it were, reading into the Act, isn't it? If you were the extradited person sitting in prison and you read this, you'd naturally read that as meaning yourself has to do everything reasonably possible. It's only when you add a sort of legal gloss or doctrine on top of that that you can make it mean something other than just what the person did himself.
Yes. Again, I accept that, my Lord. But the gloss that we are pointing to is, again, one of long-standing and high authority. And one goes back to the judgment of the Supreme Court in Al-Madawi. Again, recognising that in scenarios like this, the actions of the solicitor are to be taken as the actions of the individual. And while the lay person may wrestle with that, that's a principle the courts have repeatedly accepted. So, and one anticipates the Parliament was aware of that in choosing this particular formula. My Lords, we point out that the approach in Section 26 is largely mirrored in Section 28. So again, if something that's of some importance in the judicial consideration of this is that Section 28 is a provision for appeals against discharge. So appeals against discharge require, again, notice of application for leave and compliance with the rules and the giving of notice to all the relevant parties in the same way. It doesn't have the dispensing, an equivalent to the dispensing provision in subsection 5, but otherwise is analogous. And it's one of the points that Lady Hale comes to in her judgment in Pomachowski, is that adopting a Section 3 reading of Section 26 is potentially problematic because, again, there is a difference of approach that will follow between the requested person cases and the requesting state cases, between Section 26 and Section 28. So if we're to read a latitude into Section 26, there isn't, on a human rights-based argument, a capacity to read the same latitude into Section 28 because the requesting state does not enjoy the benefits of the Section 3 regime under the Human Rights Act. So Section 28 is of some significance to the analysis. Of perhaps more significance is Section 35 of the...
But as far as Section 28 is concerned, there is no judicial discretion available under Section 28. So the whole issue about the construction of Section 26(5) has no parallel.
Yeah, it's an imperfect parallel, I recognise that. Yes. Section 35 is of importance because Section 35 is the provision that's engaged when no notice of application for leave to appeal is actually given. So if no notice of application for leave to appeal is given before the 7-day period ends, then under Section 35, subsection 3, the requested person must be extradited to the Category 1 territory before the end of the required period. So, again, stepping back from the subtleties of the statute, in practice and in reality, and what would have happened in this case and others, is if the requesting state authorities are not told that there is a notice of application for leave to appeal, Section 35's clock will be ticking and the individual will be removed to whichever Category 1 state has made the request in the first instance. So a strict construction of the requirement to give notice is systemically required, and it's required because otherwise individuals will be potentially returned to the Category 1 states in circumstances where they actually have a valid notice of application for leave to appeal in travel. And that's the point that drove Lord Neuberger in large part to his conclusions in Michelli. Because Lord Neuberger's...
So who's the person that has to be, the obligation falls on to remove, to extradite? Because it's not the Crown Solicitors.
No, it's the...
And this person who has the obligation to remove the individual isn't notified, isn't required to be notified under the rules.
Not by the rules, no. All parties are interested.
All by Section 26. I'd just like to understand who has the obligation to extradite the individual.
The obligation is on the part of the. It's dealt with by the NCA. Yes. It's the agents are the police in Northern Ireland, PSNI, and they act ultimately on the behest or at the behest of the requesting state authorities. The Crown Solicitor's Office are the solicitors for that process. And what the rules require, and you have the rules at MS 359, starting at MS 358. These are the rules that are introduced in parallel with the new statute provisions. They introduce a new Rule 3. And you'll see at subsection 3, this is on MS 359, the applicant shall lodge the ex parte motion and supporting documents. And there's a range of different requirements for different sections. And then the tail piece of that section, and shall at the same time send a copy to any party affected by the application. So the party affected by the application is the party who bears the obligation under Section 35(3) to effect the extradition. And in practice, in the Northern Ireland jurisdiction, that's done through alerting and giving notice to the Crown Solicitor's Office. And that's the feature that applied in this case. Now again, I've already hinted at this. This is a slightly different scheme than considered in Michelli and Pomachowski, because Michelli was dealing with the originating motion for a notice of appeal as of right, no leave application filter, but a requirement of formal service. And we've now moved into a two-tier approach. It's not formal service required, but notification of the ex parte motion to the party conducting the extradition. So we say the Section 35 clock is ticking. The importance in terms of giving notice is obvious. It is potentially to the benefit of the requested person. It should be done. Where it's not done, you will see Section 35(6). Parliament has enacted a provision saying that any power to extend the period permitted for giving notice must be ignored for the purpose of subsections 1 to subsection 4A. So, a very clear provision, essentially preventing any extension of time. When we say the leave decision in this case sits uneasily with the Section 36, subsection 6A provision, as does the decision of the divisional court. And that's why we invite reflection on how does the divisional court come to its conclusion in the face of the Section 35(6) subsection A provision.
But on the divisional court's approach, subsection 6A didn't arise. There was no question of extending. I mean, this can't mean you ignore Section 26(5).
No, I agree that, Rod. Yes, it doesn't displace that, but I'm showing the court how the statutory scheme is intended to operate and the facility for extensions of time. They're not at large. It's not an interest of justice or just an equitable extension. There's a narrow gateway. The gateway is in 26(5), and the court has to find a way.
Yes.
To apply.
So there's no conflict with the divisional court's decision. Doesn't then conflict with subsection 6A because they weren't invoking any power to extend the period other than the power conferred by the statute itself in section 26(5).
Yes. So I've shown the court section 36. There are, I won't go to them now, but there are parallel provisions for Part 2 removals. The rules of court, I've shown the court those, and they were brought into effect in December 2015, just before this particular case.
Suppose that under section 26(5), formally the court doesn't extend time. It has an obligation to entertain the application.
Yeah,
Exactly.
And,
It's not an extension of time. So it's not, it doesn't abrade with the section 36, subsection 5 provision. So
How does that fit with Section 35 when, just in a case that does come within, that you accept would come within 26(5), where it's not the, nothing to do with solicitors, with the solicitors done everything possible, or there isn't a solicitor on the scene? What happens when there's leave to appeals given after the end of the period? What then? How does that impact on Section 35 timetable?
the section 35 timetable is adjusted in those circumstances.
How? Sorry, can you just show
I don't
me, because I didn't
provision right in front
follow
of
through
me.
it.
But I think there's I might just come back to that. There is a specific provision that allows for a readjustment on a 26(5) extension.
So the required period is adjusted, is it?
Yes, I think that's right. I'm at a disadvantage because I don't have the full text. Perhaps I can come back to that one.
Yeah, I didn't see how it was adjusted, but you couldn't.
I didn't see it either.
So, having set out fairly fully the operable statutory scheme, subject to my Lord Legate's question, can I turn to the Michelli, Pomachowski decisions? Michelli you'll find at MS 525 of the book, and the scenario here was similar in that, albeit under an originating motion application, there was not service of the notice of appeal, so the requesting state authorities would, on that analysis, not be aware of it. There are judgments by Lord Phillips, a brief judgment, Lord Rogers, a firm dissent on this point. The main judgment is given by Lord Neuberger from MS 538 and following. Just highlight some of the passages in the judgment which informed Lord Neuberger's analysis. Paragraph 55, he notes the importance of a consistent approach across the United Kingdom jurisdictions, because obviously the Extradition Act applies across all, and it intends to discharge international obligations. He comes back to the same point of paragraph 62. At paragraph 66, that's on MS 544, he digresses on the importance of strict timetables and refers to the engagement of section 35 of paragraph 67. Paragraph 68, he goes to the point that there's a risk that the extraditing authorities will proceed unaware of an appeal to remove someone from the jurisdiction, which is one of the underpinning features of this decision, which is later Lady Hale takes issue with that in Pomachowski. Paragraph 72, having gone through the analysis here, he reaches the conclusion that the notice must be served and filed within the 7-day period.
I mean, how could that happen? Presumably police need, if not a warrant, at least an order before they put somebody on an aircraft and...
But they have an order, my lord. They have an order from you will have the first instance judge, in this case the Recorder of Belfast, made an order on the 7th of December for the person's removal. All one has then is an ex parte application to a judge in chambers about which no one else is aware. So the judge in chambers may say, I'm granting application for leave, and no one may know.
Yeah, so until the order that the judge makes is served on the requesting or the Crown Solicitor's office, they won't be aware of it.
Exactly, that's the problem.
Right.
So it's not merely a technical requirement, it's a requirement that goes to both the interests of the requesting state and the interests of the requested person. And that's what Lord Neuberger was concerned about. Now, it's interesting when we look at Lady Hale's judgment in Pomachowski, she dismisses that as an important factor. In fact, she says the reason why you can actually, the Supreme Court could depart from Michelli is because this premise is wrong, this underpinning premise is wrong. We say, certainly for our jurisdiction, the premise is right, and this case is a case in point, because the scheme and the process and the rules have the result that in the absence of notification, a requested person can be on their way to whichever state without any interruption.
Still, the past has been sold on that point by the introduction of subsection 5, which now contemplates that leave to appeal can be given after the end of the permitted period. It's just a question of when.
Yes.
I'm still not sure how that operates in conjunction with 35, but it has to operate in some cases, and if it can operate in those, it's the same problem if it applies to more.
Yes.
In practical terms, somebody's being put on a plane, they're going to bring an application immediately to the court and make everyone aware of what's going on.
In most cases, my lord, yes. Maybe perhaps not in all, but in most.
I don't know if the procedure followed in this case was typical, but we've seen in this case, however, were effectively procedural hearings before the divisional court, so that they knew and the parties knew what the timetable of hearings was going to be.
Yes.
So for example, the Crown Solicitor's office were aware of the fact there was going to be a hearing of an application for leave. Before that, they didn't have to wait to be told what the outcome of that hearing was. They knew the hearing was taking place.
They on this chronology, they didn't know until the 4th of January, whenever they are made aware, long after they should have been, that there was an application for leave to appeal. Now, had the clock been driven as it should have been driven, there was every prospect that this individual could have been removed before they were made aware of it. As it happened, it didn't unfold that way. But looked at in the abstract, the system can function in such a way that the rights of the individual are not protected if there is no notification given to the state. And that's what Lord Neuberger was concerned about. Not the totality of his reasoning, but that was an important factor for him in the Michelli decision. The court then considered in paragraph 73 and onwards the question of whether time could be extended. And you'll see quite a detailed treatment of section 35(6)(a), which we've been discussing at paragraph 76. And he ultimately reaches the conclusion in that case that it wasn't open to the court to extend time under 26(4) as it stood then. Lord Brown's judgment is short and supportive on that. I'll just highlight for your lordships paragraph 37, that's at MS 538, where he flags just below letter D that there's actually very little purpose in allowing flexibility as between service and filing, because he notes it would give rise to a disproportionate disadvantage with the complete loss of clarity and certainty so essential to the efficient and expeditious working of the new extradition scheme. So again, the importance of certainty highlighted by Lord Brown. There is a detailed dissent by Lord Roger from paragraphs 4, MS 531, where he, informed in part by a different approach in Scotland, takes issue with the inability to extend a requirement found in rules rather than in the primary act. So the principles of Michelli are still operable, albeit that was directed to an originating notice. The matter came before the Supreme Court in 2012 in Pomachowski. The only common member of the panel was Lord Phillips. You'll find that at MS 610. It was an appeal involving 3 Polish nationals being subject to a Part 1 return and a British national subject to a Part 2 return to the United States. It's the British national case, Mr. Halligan's case, which is the analogue to our case, because in his situation, notice was not given by his solicitor to the CPS, so the defect was directly analogous to this case. So this judgment postdates the parliamentary review in which Lord Justice Scott Baker had conducted, and you can see that just in passing, reference paragraph 34, where he discusses that process, and you'll find that at MS 630. But the consideration by Lord Manso of Michelli is significant. You'll see the relevant portions of the judgment can be found from MS 620, paragraph 14 onwards. So there's a general discussion of the factual background of Halligan's case, an examination of Michelli. At the top of paragraph 17, page MS 622, Lord Mance poses the question of whether the Supreme Court should apply or decline to follow the decision of Michelli. And you'll see below letter C, he refers himself to the general structure of the relevant sections of the Extradition Act, the distinctions between appealing or bringing an appeal, the need to give notice, and I think that's difficult to reconcile with any conclusion that some form of notice is not required. It refers back to Lord Newburger. I would not therefore depart from Michelli insofar as it requires not merely filing an appeal, but also some form of notice being given to the respondents, both within the permitted period. So that's the ratio dis idendi of the Supreme Court's consideration in Pomachowski on the issue under consideration here, absent any Section 3 reading. So Michelli is endorsed by the Supreme Court in this judgment. But Lord Mance goes on to examine a particular issue arising out of Halligan's case. Because Halligan was a British national being extradited to the United States, the court engages in an analysis here of convention rights, Article 5.4 and Article 6, and whether or not the removal in these circumstances would be consistent with the convention. So there's then a discussion of these points, which follows from paragraphs 34 onwards. You'll see at 36 a discussion of what's sometimes described as a surrogacy principle, whether an individual is held to the fault of their legal advisors, in reference to House of Lords' decision in Al-Madawi from 1990, which I've already flagged for you. And the Divisional Court in Northern Ireland found this passage in 36 and 37 to be important, and they laid weight upon it. I'll come back to that. Paragraph 39 is central to the Supreme Court reasoning, or Lord Mance's reasoning here. And bearing in mind again, he is looking at this in a pre-amendment stage. Paragraph 39, the first sentence is important and the last sentence is important, we say. In the present case, Lord Mance says there's no reason to believe that Parliament either foresaw or intended the potential injustice which can result from absolute and flexible time limits. It intended short and firm time limits, but can only have done so on the basis would practice suffice to enable anyone wishing to appeal to do so without difficulty in time. So at that point, the Court's informed by the fact that Parliament hadn't given direct consideration to the issue. Post-2014, the circumstances are different. We now know that Parliament has given direct consideration to this and has created the formula in section 26.5. Lord Mance, at the bottom of that paragraph, the final sentence, reaches the view that the High Court must have power in an individual case to determine whether the operation of the time limit would have this effect. If and to the extent that it would do so, it must have power to permit an here and out of time appeal, which a litigant personally has done all he can to bring and notify timiously. So that passage in Lord Mance's speech, learned friends will no doubt rely upon that and say, well, that's exactly our scenario. The situation here, Mr. O'Connor's done everything he could, therefore he ought to have the benefit of a dispensation. Now, Lord Mance doesn't expressly say that he's engaging in a Section 3 reading, but it's fairly obvious from paragraph 38 that what he's looking at here is whether or not the statute provisions are incompatible. It's a Section 4 case, or whether it's a Section 3 reading that's required. So the Section 3 reading is not spelt out in terms, but is found essentially in paragraph 39 of that judgment. Lady Hale's judgment is interesting. It follows, and her approach is to favour a departure from Michelli entirely, and you'll see that at paragraph 44. She takes the approach that Lord Newburger's assumptions were incorrect, and she bases that on practice in the Westminster Magistrates Court, the fact that the Serious Organised Crime Agency will be aware of these matters, and she is of the view that the better course is to depart from Michelli entirely. Paragraph 46, she notes that they're not constituted to deal with it. Paragraph 47, she says, well, there are two ways forward to address the kinds of hardship that arise here. One is to depart from Michelli, and the other is to engage in a Section 3 reading. Of interest, my Lords, you will note at paragraphs 52 and 53, Lady Hale identifies some problems with a Section 3 reading to introduce this element of flexibility. She notes that it discriminates between nationals and aliens, between requesting persons and requested persons, because a differential approach applies. And she recognises at 53 that a reading down of the notice provisions would be equally applicable to the other filing provisions. So flexibility read in through Section 3 could have a collateral consequence to other aspects of the scheme. But ultimately she supports Lord Mance's conclusion. The intervening step that follows Pomachowski, and I'm not going to open any parliamentary materials. I've read this court's judgment, Lord Reid's judgment in SC, and the limited approach which we should now adopt to the use of parliamentary materials. But we know that following Pomachowski, the 2014 amendments were introduced. We have leave, and we have the bespoke provision in 26.5. And that matter, the functioning of those amendments, came before the Divisional Court in England in Segfu. You'll find this at MS 697. And again, factually parallel case to that which we are considering. Efficiency there in giving notice, filing the appeal, the application for leave to appeal, and giving notice. The court considers the new provisions. This is one of the first cases in England to address the point. You'll see at paragraph 11, MS 701, discussion of the legislative response to the observations of the Supreme Court in Pomachowski and the review. Parliament didn't choose either of the alternatives referred to, opted for a solution which doesn't engage a general discretion, but equally does not import a different or albeit longer time limit, and sets out there what 26.5 refers to. You'll see at paragraph 14, the court observing that we're not dealing here, as I've observed several times, with a just and equitable extension or something of that nature. It's a specific formulation for this case. Paragraph 15, Divisional Court examines the use of the word person in section 26.5. And you'll see it paragraph 17, it's consideration of that word being used twice. And we say again that aligns with the analysis that we've set out in our case. Paragraph 18, the Divisional Court here looks back to what Lord Mance was concerned about in Pomachowski. And what Lord Mance was concerned about in Pomachowski was the complete erosion of the right of access to an appeal. So the very essence of the right to appeal was being extinguished in some of these cases. That was the concern that Lord Mance had articulated. Divisional courts say, you'll see it just above letter F, once this has been instructed, it cannot be said the essence of the right to appeal has been denied if their default results in it not being pursued in time. The advice which Parliament was dealing with does not call for the distinction being made, and again then notes the need for swift application of the rigid time limits in the statutory scheme. And paragraph 19 notes the refusal of the Supreme Court to depart from Michelli in Pomachowski and addresses the question of both service and filing. So the decision in Shagfu was there was no flexibility in circumstances where the default was that of the solicitor.
Was that the decision? Because if you look at paragraphs 29 and 30, on one view, I haven't looked at it carefully, the fault was the fault of the individual personally. And so the comments about surrogacy are all obiter. I certainly couldn't find this was the fault of the solicitor. We're attributing this fault to the individual, therefore we're not going to hear the appeal.
Yeah, I don't think it's expressed in those terms, Lord. It is also a slightly different case insofar as the feeling was more fundamental in that there wasn't a notice or notification given. So it's across two dimensions.
If at some stage you could come back and say whether or not the views expressed by the Divisional Court about surrogacy are obiter or not.
Certainly, the question of the Divisional Court's views on obiter or on surrogacy rather was of some importance in our Divisional Court because we were examined and asked to go back over that issue several times. I'll come back to that point, Lord, if I may.
Thank you.
It's also worthy of note, I think, that the Divisional Court recognised that the consequences of their approach could result in some outcomes that were plainly oppressive to individuals. And in that case, the application for leave failed. You'll see that at 31 and 32. The court did, in an interesting endnote, paragraphs 33 and 34, avert to the fact that there may be extreme circumstances, where notwithstanding the fact that we have a self-contained statutory scheme for appeals, there may be some extreme circumstances where it is open to an individual to bring an application for judicial review, even if the statutory processes have all been exhausted. And there's a reference there to cases like Klimeto and Navadunskis, which are, again, slightly older authorities on the point. So the Divisional Court seemed to form the view that there was a final ultimate potential backstop in a truly difficult case by way of a judicial review application, that the door was not completely sealed, closed to potential remedy. As we understand it, the Chegfu approach has been followed in England and Wales since that time. The Northern Ireland Divisional Court, as we've seen, considered this case in 2016 and 2017, gave the judgment under appeal in August of 2017, and the judgment the court has at MS 509. It appears in several places in the Book of Authorities. But 509, you'll find the text. And it's a brief judgment. It examines Michelli, paragraph 5, Pomachowski, paragraph 7, the Chegfu decision at paragraph 10, paragraph 12. This is the key to the conclusion. Chegfu was suggesting that strict time limits could deny the very essence of the right to appeal. Paragraph 13, I think, has an error in the first sentence. The court, being the Divisional Court in England, went on to conclude that once solicitor to be instructed, it could be said the right to appeal had been denied. What they actually said was it could not be said the right of appeal had been denied. The conclusion proceeds from the assumption the purpose of the provision was to exclude injustice, and the Northern Ireland Divisional Court said they did not accept that interpretation. Noted it's nothing of a remedy to be able to sue the legal advisors. That's the first point they make. Secondly, they say Chegfu did not address surrogacy in Pomachowski. And thirdly, they refer to Lord Mance's analysis of the injustice that can arise from absolute and inflexible time limits. So that's the reasoning of the Northern Ireland Divisional Court. What we say is missing in the analysis here is what approach the court is taking to the construction of Section 26(5). Because if it's following the Pomachowski approach, then one would expect to see here a consideration of a Section 3 application, whether or not the provision should be read in a different way. If so, what that reading should be, whether or not it involves consistency or inconsistency with the provisions of the statutory scheme. But there's nothing of that in the Divisional Court's reasoning. It's not clear at all how we get to the end point.
Well, isn't it tolerably clear that they're considering two possible interpretations of the wording, one in which solicitors' acts are attributed to the person and another in which they're not, and they're coming down in favour of the interpretation? Just a matter of construction that the solicitor's acts are not attributed in this context.
Well, if that's the case, then it's not a Section 3 reading at all. It's just a question of statutory construction.
Exactly. Well, that's what I take it to be. At the top of the page, is that either interpretation will be consistent with the words used, and then they go down to consider the two alternatives.
Well, that may be the case, and if that's the case, then we're not engaged in a Section 3 analysis or anything like it. It's a simple question of statutory construction. We're left then with the two competing approaches, the approach of the Divisional Court in Chegfu and this approach.
And what's the answer to their point that it's not much of a remedy? to say that you might be able to launch an action against a solicitor. I mean, that's pretty fundamental, isn't it? Difference between a situation where your solicitor misses a time limit and you're claiming some money, or circumstances in which you're off to another country and it's useless, really.
Yeah, I don't contend that that's a remedy in the circumstances. That's a potent enough observation, but it's in the context of an extradition scheme where what the United Kingdom is doing is discharging its international obligations in the expectation they're discharged in the same way. It's something above the normal private law considerations that might apply in respect of solicitor's negligence. So it's a slightly different paradigm, and so I don't downplay. There's a potency to that point. I don't think it's dispositive of the issue, because we have to look at this within a broader frame. The courts have been concerned to ensure that we have a systemic functioning scheme of extradition that operates reciprocally. And if we start disrupting it through interpretations like this for hard cases, then we disrupt the scheme. That's, we say, what underpins Michelli and what underpins Lord Justice Burnett's analysis in Shegford.
But you said it's the same wording in Part 2, and Part 2 arrangements aren't reciprocal.
Yes.
And Part 2 arrangements might include the death penalty, in which case a right of recourse against your solicitor certainly wouldn't be much of a remedy.
Yes, well, I recognise the force of that point, Lord. I mean, it has force in respect of Part 1, perhaps greater force in respect of Part 2, but again, we say it's not necessarily dispositive of the issue. So, my Lords, the position as it stands, we say, is and remains unsatisfactory insofar as we have competing interpretations in the divisional courts in the United Kingdom. Which path should be followed? We say, consistent with Shegford, the analysis that's opted there is to be preferred.
What do you say about the specific points in paragraph 14, which they make about Shegford? We've discussed the no remedy point, but what about the second and third points? Are they not fair comment?
There is a point in respect of the surrogacy principle. Lord Stevens has asked whether or not it's really an obiter issue at all. The surrogacy argument has been in the background in Michelli and in Pomachowski. If you actually, it's not addressed in any substantive analysis in Michelli, but all the authorities on surrogacy were before the House of Lords in 2009. They were before the Supreme Court in Pomachowski in 2012. There is a difference of some substance to be drawn between the surrogacy line of authority in deportation and asylum cases and extradition cases. Deportation and asylum cases, like AFP Iran, have adopted the approach in respect of the surrogacy principle that it's not universal. But extradition is different. Deportation and asylum are domestic law concerns only. Extradition involves matters of international obligation. And Lady Hale recognised that in H&H, which I think the judgment was given just 3 weeks after. In Pomachowski, you have H&H at paragraph MS 448. And there's a discussion of this from paragraphs 28 onwards. That's MS 465. And I won't read all of this, but the thrust of this is that there are proper distinctions to be drawn between the approach in deportation and asylum cases and extradition cases. You'll see that examined at 28. At 29, she doesn't accept that they are radically different. At 31, recognises that there are differences between extradition and other reasons for expulsion. And extradition may be appropriate where deportation or removal would not. It's a reciprocal obligation point that I've already made. So the surrogacy principle read across, we say, is, and of which my learned friends will no doubt make submissions, we say is, again, not determinative of the issue here, because the scheme in extradition is conceptually different. The third point that the Divisional Court of Northern Ireland make is that the benefits of the Section 26(5) dispensation should not be limited only to the unrepresented litigants. Again, we say that...
And that was Lord Mance's view, wasn't it?
That was Lord Mance's view.
Yeah.
Yeah.
And it was based upon a whole lot of instances of unfairness leading up to the introduction of this legislation.
Yes.
Which weren't confined to unrepresented litigants.
That's right, my Lord. I suppose what we say in respect of that is Lord Mance clearly diagnosed the problem. In the last sentence of paragraph 39, seemed to identify a solution. That's not the solution the Parliament adopted. No, that's open to debate.
That's the question.
That's the question. It would have been easier had they adopted precisely the formula Lord Mance had prescribed, but they didn't. Well,
it wouldn't fit easily with person, would it?
Yes. So we say that clearly the Divisional Court in Shegford looked at all of that and reached the conclusion.
Was it Parliament's intention to confine the possibility of injustice to unrepresented litigants?
Well,
or is the purpose of the flexibility to enable access to the courts so that appeals can be heard in deserving cases? Without confining them to one particular category.
We're adopting a self-denying approach to the proceedings in Parliament on this issue, but it seems that one of the driving concerns was the difficulties for unrepresented litigants who are in the prison system and who can't access the things that they need to access in order to engage with the process. In this case, O'Connor and others like it, that's not the scenario we're dealing with. We're dealing with people who are represented at every stage of the process, who have properly engaged solicitors, who are running and are legally aided and funded for the appeals, and who default. That's not the mischief that Parliament was trying to address, protecting against mistakes of that nature. It was driving at the difficulties for the individual unrepresented prisoner in the system who faced a 7-day time limit. So, my Lords, we say of the two decisions, the decision of the English Divisional Court is to be preferred. What must happen, we say, is a reconciliation. And that's, we say, why the matter was properly given leave by this court. And it will be to the benefit of all practitioners in the field if we reach a level of certainty in respect of that. Lords, I've probably reached the end of my submission slightly earlier than I'd anticipated. If the court has other questions, there are one or two points which I'll address in reply, in particular Lord Stephen's question, but aside from that, and with apologies to my learned friend, those are my submissions.
Well, there's no need to apologise to the court, at any rate, for finishing your submissions earlier than anticipated. Thank you very much, Mr. McGlynn. Mr. Mohammed.
My Lord, please the court. My Lord, can I respectfully say at the outset, there's much with which my learned friend has already submitted in terms of the analysis of the law, in terms of the approach that was taken in several of the preceding cases that we do not demur from. But fundamentally, what we do respectfully submit to the court is this is a matter of pure interpretation. And it's the backdrop and context in which one arrives at the decision-making process, both in Shegfu and also in the Divisional Court decision in Northern Ireland of O'Connor, that is of, in our respectful submission, of import in these present circumstances before this court in this appeal. And perhaps the starting point is, and again, I wish not to labour the court, is the dissenting judgment in Mucelli of Lord Roger. And in the course of that, in somewhat colourful terms, on the analysis of, as it was then, the strictures around 26.4, it's set out at paragraph 4, my Lords, at page 531, that the interpretive approach to be taken in relation to 26.4 and the corresponding Part 2, Section 103, is that unusual circumstances, when dealing with issues around what are procedural matters, then usually that is not a matter for Parliament. It stops at the door of the court. Quote unquote, Parliament doesn't teach its grandmother to suck eggs. On this occasion, however, bearing in mind the nature and background to the extradition scheme as set out in statute, one of the primary objectives, of course, is expedition, it is efficiency, and part and parcel of that, therefore, Parliament has determined should require rigid time frame and time limits. But of course, that must be seen, in our respectful submission, in the context of Mucelli, where the concerns raised by Lord Roger when considering specifically such a statutory scheme, in instances where, for example, as he sets out, it's page 532 of the electronic bundle, at paragraph 7E, a relatively short but utterly rigid deadline for bringing an appeal is readily understandable. Even so, it imposes a substantial burden on a prospective appellant and his advisers. And then he goes on over the remainder of that paragraph, my lords. The question is whether Parliament had considered exceptionally the matter of service had to be taken out of time of the hands of the courts, etc. And continues on, paragraph F through to G, the potential for substantial injustice is striking. Busy practitioners with many demands on their time may, quite understandably, fall down from time to time. And perhaps to adopt the phraseology of Lord Stevens, bearing in mind the purpose underpinning the statutory scheme, there must be instances in which there are deserving cases. And in our respectful submission, it is not adopting a denying approach to Parliament, as my learned friend would suggest, but to the contrary. There is a common thread sewn throughout the jurisprudence leading up to the amendment to the Act in which Section 26.5 was given effect. And it starts with, in many ways, the concerns voiced and expressed by Lord Roger, but also at page 530, whilst Lord Phillips, having had the benefit, and of course we wholly concur with my learned friend's observations on the general broad principles of Mucelli, Lord Phillips, at page 530, on the third line between paragraphs H and J, my lords, I've had the benefit of reading and draft the speeches of my noble and learned friends Lord Roger and Lord Newburger. Not without some hesitation, I align myself with the reasoning and conclusion of Lord Newburger. And clearly, it is the caveat with which, at that juncture, the application and the strict application of Section 35 arises in circumstances where there must be efficiency within the scheme. Perhaps, if it's convenient to the Court at this juncture, to address very briefly one of the questions posed to my learned friend. The clock does stop. The provision for that is Section 35, subparagraph 7. And the consideration, of course, in circumstances is that there is a very strict time frame. It's presently 17 days from the making of the order by the court at first instance to the removal of the, as it would be, purported appellant from the jurisdiction. 17 days in this instance, and was acknowledged at the outset, had been passed in the fullest sense. But remarkably in this case, as an aside, no steps had in fact been taken during that 17-day period to trigger the statutory provision on behalf of the requesting state. One may infer from that clearly, by whatever means, they were on notice. And the significance of that, my lords, and I'll perhaps come back to this, I'm digressing slightly, is there is provision within Section 35 that permits in such circumstances the setting aside of the order. Going back to
Once the 7 days has run out, you're in peril, presumably,
Yes.
Even if through no fault of your own you haven't got a solicitor, you could still be removed. And if that happens, there's no going back after. But even if Section 26(5) is in play, because admittedly.
I respectfully concur, my lord. It is the perilous state that one is placed in by reason of such a rigid time frame, which clearly resonated with both Lord Roger and also in the observations expressed in his opinion by Lord Phillips in his speech. It is by reason of the background of that we do respectfully say that when one then considers, and I take on board wholly the observations and ratio of this judgment in the SC decision, both in relation to the President of the Court and also Lord Stevens. But of course, we're not dealing in this instance in a consideration of the compatibility of convention rights. This is purely a matter of interpretive consideration. And the Coastal and United Kingdom decision is, we respectfully submit, a matter that does, in terms of this court carrying out the interpretive role, not merely looking at the statute, the explanatory notes, etc., that Pepper and Hart, does, respectfully we say, open the door to what may be of some assistance in putting the parliamentary changes into context. Because the report by, as he was formerly...
I really don't think you need to rely on it. If you point to the background,
yes,
and what the mischief was that was intended to be addressed, that's going to be rather more powerful than, unless you have something very powerful. If it's just stray remarks in the course of a parliamentary debate, then it's really neither here nor there.
The background, my lord, yes.
What's it called? Pepper was itself quite a strict test. Well, it imposed quite a strict test, and it's been the whole tendency of the law ever since has been to put a restrictive gloss on it.
Yes. In this instance, my lord, what I do respectfully submit to the court is this: that when one considers the Scott Baker report, it is quite compelling in terms of the answer to the question before this court, because within it's a page, the electronic bundle of page 771, there is an acknowledgement at paragraph 10.3 in the first instance of the problems being caused by Mucelli. And the culmination of that paragraph reads, "This strict deadline has led to a number of appeals under Part 1 being ineffective for want of jurisdiction. We have received several representations that this produces an unfair result. A number of judges have also highlighted the unfairness in their judgments." At this point, the footnote is the Halligan decision as it had been at first instance upon appeal or upon challenge before the Divisional Court, in which Lord Justice Laws, who, along with Lord Justice Stadlin, gave the judgment and made the following observation, and this is the observation that's also expressly referred to by Lord Manson-Pomachowski when the matter comes before the Supreme Court. "It would seem to offend the basic principles of fairness that a person served with a notice of extradition should be deprived of a statutory right of appeal through no fault of his own." And that, we respectfully submit, is at the very heart of the distinction that one can and should draw under 26(5) in the consideration of the interpretation of the word person. It is the very phraseology that is subsequently then used at the subsequent point in the reading of the bill with this particular provision, as it was, before the House of Lords by Lord Taylor. in which he expressly cites the very same phraseology. But before perhaps turning to that, if I may respectfully just finish with this aspect of the Scott Baker report. Another stark example is set at a 10.4, the case of Mann, again, in which a failure on the part of the lawyers to file and serve the notice of appeal within the 7-day period. And yet, as Lord Justice Moses concluded, I accept this court is powerless to act. It has no jurisdiction. At 10.5, it then observes that there are further problems for defendants. Sorry, yes.
Go on, if I may. The cases referred to in footnote 4, are they ones where there was a solicitor's failing?
Yes, the one that we rely upon is the failing in Halligan of the solicitor. Yes, my Lord.
Thank you.
And 10.5, and I respectfully merely ask the court to note this in passing at this juncture, but this is an important observation we respectfully submit when one comes to the consideration of Shegfu. There are further problems for defendants who are in custody and unrepresented. In other words, the Baker Review identified one source of injustice emanating from cases where there was legal representation. And in addition to that, there were further problems again in terms of the statutory scheme for defendants in custody and unrepresented. But there was a disconnect between the two. There were two separate potential sets of problems. And obviously in instances there may be to some degree an overlap. My learned friend has dealt with the possible mechanisms. I don't intend to rehearse that. And then of course, when turning to the specific provision pertaining to the time limit for the notice of appeal, my Lords, it's electronic page number 775. At subparagraph 11.75, we believe that the inflexible time limit for the filing and service of a notice of appeal for Part 1 cases is operating to cause injustice. So at the very heart of this review was the acknowledgement, and a review, of course, that at that time had been directed by the then Home Secretary Theresa May, in which one of the principal causes for concern was the question around potential injustice. My learned friend has already made the point in terms of the introduction of the two-tier leave to appeal stage. When one, my Lord, steps back and puts this into context, in effect, the introduction of the leave stage was to weed out what candidly appeared to have been the greater number of cases which were deemed to be unmeritorious. It was to remove them at an early stage from the system, to avoid the system being clogged up, to avoid inordinate delay, and therefore, on the one hand, by an appellate leave stage being introduced, that was an early point to filter such cases. But that, of course, left the meritorious decisions or cases upon which such issues under the Convention may arise. And of course, in our respectful submission, it's very clear that the observations, both in Micheli and as we come on to Pomocescu, those were the cases at which there was a concern if there was to be an inflexibility within the scheme. So there were, in our respectful submission, 2 points in terms of the approach to the statute. One was efficiency in tandem with justice being done in meritorious cases. By reason of that, when the matter did, in fact, reach both before the second reading of the bill before Parliament, this is set out when the bill was introduced by the then Home Secretary Theresa May, and subsequently, as I say, before the House of Lords. And that's found at pages 782 through to 784. And the phraseology at the top of 784, adopted by Lord Taylor, expressly states, as I have said, we have introduced new protections where people are unable to submit their appeals on time through no fault of their own. The very phraseology that had been used by the court in Halligan is the same phraseology we find being cited in this instance, and also cited with approval then in the Supreme Court in Pomachevsky by Lord Mance. When one turns to the decision in Pomachevsky, and my learned friend has already dealt with the factual matters, but perhaps just to elaborate on those slightly further, at page 611 of the electronic bundle, contained within the headnote at paragraph B through to D inclusively, sets out in some detail the decision of Mr. Halligan in terms of the factual matrix, and of some significance is that in that scheme, because it came within category 2 of the Act, the order and letter notification being to the Secretary of State. As it so happened with Mr. Halligan's case, at subparagraph C, the order having been made in the first instance by the Magistrates' Court, the letter informing him of that right, as it was under the provision of 108, to give notice of appeal within 14 days to the High Court, and pointed out that such notice required both filing and service, and that any papers filed at the High Court had also been served on the Home Office and the CPS, Crown Prosecution Service. Within that period, the arrested person himself sent a fax from the prison to the Home Office asking them to accept this letter as notice and service of my attempt to appeal, but his solicitor failed to send his notice of appeal to the Crown Prosecution Service and the Home Office within 14 days. That being the background to whether, in fact, the ratio of Michelli would apply, at page 621 of the judgment of Lord Mance, he gives some further detail around what in fact had occurred with Mr. Halligan's case at paragraph 15. And perhaps somewhat pointedly, the first sentence simply reads, Mr. Halligan had solicitors. And the significance of that, we respectfully submit, is this. At subparagraph C, having set out the scheme, the notice requirements and so forth, it states, Mr. Halligan himself wrote from prison by fax to the Home Office, asking them to accept this letter, which we've already touched upon the preceding page, and continued, my solicitors have been duly instructed, and this letter is only necessitated by the imposed due date of the 4th of January 2011, and my inability to make contact with them given the restrictions imposed within the prison. As Lord Mance observes, his apparent concern was justified since his solicitors let him down, etc. So that is the background to which, from the facts pertaining to Michelli, the consideration was given by Lord Mance in Pomachevsky to what is relevant and central to this case, the default of the solicitor in circumstances where otherwise arguably the surrogacy principle may in fact bind the inaction of the solicitor upon the unfortunate putative appellant. But it is in the context we do respectfully submit that when one looks as to his rationalisation in coming to the distinction that is and should be drawn between extradition cases and immigration cases, that extradition should be viewed through the same prism as applies in those cases of asylum in which FP Iran and Lord Justice Sedley concluded that the surrogacy principle is not a universal principle. And I would respectfully invite the Court to consider the passages from 34 through to 36, which deal expressly with the distinction that is drawn. And within that distinction, and the appellant in this instance seeks to rely upon the decision of Lord Bridge and Al-Muwadi, reference to it in Nori. But fundamentally, when one considers and reads on in the Al-Muwadi decision, the very same phraseology is used by Lord Bridge, where a residual discretion, even after, in immigration cases, even after the statutory scheme has been exhausted, the Secretary of State retains a discretion to refer the matter back to the panel so that the appellant can make oral submissions. And perhaps when one considers the phraseology used as to when that should occur, and this is page 405 of the electronic bundle.
Well, you gave us a reference to Lord Justice Sedley, I'm afraid.
Yes.
Where was that?
I'm sorry, my lord, that case was in the decision of FP Iran. So FP Iran is found at it's at page 630.
Thank you very much.
And I'm hoping to return to that briefly. And that was in the context in which, in the consideration of the surrogacy principle, the elucidation of it not being a universal principle as approved by Lord Mance, emanated from the decision of Lord Justice Sedley in FP Iran, specifically in relation, in that instance, to asylum cases. And whilst Al-Muwadi and part of the judgment is quoted in terms of Lord Bridge, what I respectfully invite the Court to consider is the substantive paragraph at page 405 between subparagraphs A through to D inclusive, and in particular, this is Lord Bridge stating, "It is perhaps worth pointing out in the last 4 lines, it would, as it seems to me, certainly be open to the Secretary of State, if persuaded that the merits of a case required it, to invite an adjudicator to hear the oral evidence of the appellant whose appeal had, again, through no fault of his own, been dismissed in his absence." So here we have it even in the context of immigration, which is why we respectfully submit in at the core of our written submission, one must look to justice and the potential risk of injustice. That surrogacy, as it may normally be deemed applicable and appropriate, is not a natural read across into the Extradition Act. In such circumstances, both in terms of the observations of the President of this Court when one considers Category 2 type instances, but also even within Category 1, when one may also be dealing with potential infringements under Article 3, as in this instant case. As my learned friend admits, it seems to be the reading down, albeit it's not spelt out, within Pomachowski by Lord Mance at paragraph 39 onwards, is we respectfully submit also of relevance to this current appeal. In the obiter remarks at paragraph C of paragraph 39, and this has been touched upon already.
Just remind me as to the page number.
I apologise, my Lord. Yes, page 632.
Thank you very much indeed. Thank you.
And at page 632, paragraph 39, between subparagraphs B through to D, at paragraph C, the High Court must have power in any individual case to determine whether the operation of the time limits would have this effect. And the effect he's referring to is the risk of injustice. Access to justice being a fundamental aspect of that. And it is in that context, if and to the extent that it would do so, it must have power to permit and hear an out-of-time appeal which a litigant personally has done all he can to bring and notify timiously. So that very much was the backdrop when the legislation came before Parliament for the purpose of the amendment. And it was in the acknowledgement within the debates by the then Home Secretary that whilst the provisions must operate efficiently, they must also operate fairly. And that, my lords, is found at page 779 of the electronic bundle in the final 3 sentences contained in that paragraph. In summation, among other things, the bill addresses the current unfairness that can arise from the strict operation of the time limits for serving an appeal against extradition. So when one considers the practical application of that in a case such as this, perhaps to explain the rationale as to why we do, in our written submission before this court, immediately accept that in any consideration of the statutory interpretation of section 26, subparagraph 5, one must of course look not only at the individual, but also at those actions that are taken or deemed to have been taken on his behalf. Whether in fact those happen or not is perhaps a secondary consideration to the court assessing what steps have been taken. And therefore, in all circumstances, we do respectfully submit that in the outworking of instructions, for example, given to a legal representative, then the interchangeability within the definition of person would incorporate the positive acts, the positive directions given by any potential applicant or potential appellant to his or her solicitor. But we do respectfully submit there is a second part to that. It should then come back to the steps taken by that individual or the intended or anticipated steps to be taken on behalf of that individual should be the focus. Because ultimately, otherwise, if one were to apply SEGFU, which I'll open briefly before lunch if I may, but otherwise the inaction of a solicitor would, in any instance where notice of appeal has been served out of time under 26.5, would mean that even meritorious appeals simply could not be considered. And when one considers the rationale underpinning the context, background and purpose of this amending provision, in our respectful submission, that clearly was not the intention of Parliament. If, and I'm entirely in the court's hands, I can very briefly touch upon the factual side of SEGFU, perhaps in order to address Lord Stephen's query about whether the ratio is dealing expressly with surrogacy, or whether in fact the remarks of Lord Burnett are merely obiter within the case. And perhaps to assist with that, if I may. Thank you, my lords. Segfu being an extradition case to Hungary, it's a Category 1 case, and the order was made before the Magistrates' Court on the 12th of March 2015. Mr. Segfu represented himself at that hearing, having previously dispensed with his solicitor. And that's found, I'll not open it at this juncture, but that, my lords, will find at page 697 of the electronic bundle is the citation one finds the Segfu case. Mr. Segfu was released on the same date the order was made, unlike Mr. O'Connor, who was remanded into custody. Mr. Segfu, on the 16th of March, in other words, within 4 days, lodged an application for asylum. I'll get the specific statutory reference for this over lunch, but in effect, by so doing, the clock stopped in terms of his removal under the extradition order. One may infer from that that Mr. Segfu was clearly conversant with the statutory scheme in place. But in any event, on the 15th of April, the following month, Section 26(5) was given effect. And 2 days later, he met a solicitor who was not on record for him, but agreed to assist him with the completion of his notice to appeal the extradition order, which took place on the 20th. Between the 20th and the 27th of April, Mr. Segfu, who had taken it upon himself to file that notice, failed to do so. And at the very heart, at paragraph 30 of the judgment, at page 704, the court made the observation, the week's delay between the 20th and 27th could not be reconciled on any assessment of whether Mr. Segfu fell within 26(5). It was in those circumstances that Mr. Segfu's application was in fact refused. The question around the role of the solicitor within that case is very limited, factually, and also in the consideration of the legal jurisprudence. It appears that the court did not have the benefit of either the parliamentary debates. There's no reference to the Baker Review having been opened before the court, but far less is there any reference to paragraph 36 in the judgment where Lord Mance deals with the surrogacy principle not being of universal application in Parmucheski. And that, we respectfully submit, is the prism through which this court must look at the decision in Segfu. My Lord, I see it's now 1 o'clock. If that's a convenient time.
Can I just be clear, if I may? So, in answer to my Lord Stevens' question, you are saying that it's effectively obiter dicta?
I am indeed. Yes, indeed.
Thank you.
Thank you.
Yes, we'll adjourn then and resume at 2 o'clock.
Thank you, my Lord.